This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws, which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. Under the Ohio Public Records Act, any person may request to inspect or obtain copies of law enforcement investigatory records. However, law enforcement agencies are permitted, though not required, to withhold certain investigatory records if they are covered by the confidential law enforcement investigatory records exemptions. These are commonly referred to as the CLEIRs exemptions and are listed under Ohio Revised Code Section 149.43A2. A confidential law enforcement investigatory record is defined as any record that pertains to a law enforcement matter of a criminal, quasi-criminal, civil, or administrative nature, and that, if released, would create a high probability of disclosing any of the following information: the identity of an uncharged suspect, the identity of a confidential information source, specific confidential investigatory techniques or procedures, specific investigatory work product, or information that would endanger the life or physical safety of law enforcement personnel, a crime victim, a witness, or a confidential information source. Applying CLEIRs is always a two-part test. To meet the first part of the test, it is important to know that the CLEIRs exemptions apply only to records that pertain to a law enforcement matter. To qualify as pertaining to a law enforcement matter, the agency activity involved must meet each of the following criteria. The investigation must have been initiated in response to specific alleged misconduct. The alleged misconduct must violate a criminal, quasi-criminal, civil, or administrative law, and the public office keeping the record must have legally mandated investigative or enforcement authority over the alleged violation of the law. Let's discuss each of these parts in more depth. To meet the first part of Step 1, the investigation must be in response to specific alleged misconduct or wrongdoing, not just routine monitoring. However, records that initiate an investigation, such as an initial written complaint, a 911 call, or a routine incident or offense report form, are not considered part of the investigation. Because these pre-investigation records do not meet the first part of the law enforcement matter test, they are not covered by CLEIRs. Under the second part of Step 1, be aware that CLEIRs covers more than just criminal investigations. It includes investigations of any conduct that is statutorily prohibited and punished by criminal, quasi-criminal, civil, or administrative law. Criminal investigations by local law enforcement and prosecutors are criminal law enforcement matters. Investigations by those offices of juvenile violations of criminal law are also considered law enforcement matters, but are quasi-criminal matters. Also covered are investigations by agencies, such as the Environmental Protection Agency, when pursuing civil law enforcement against violators of environmental statutes for fines and other civil penalties. As a final example, investigations and discipline by administrative licensing boards, such as the Ohio Board of Psychology, are administrative law enforcement matters concerning licensees violating professional standards. On the other hand, CLEIRs does not apply to disciplinary personnel investigations of a public office's own employees, even if the disciplinary investigation is of employees of a law enforcement agency. It also does not apply to employment background checks for any public office or to any other investigation that is not of a law enforcement matter. Under the third part of Step 1, an office must have a legally mandated investigative or enforcement authority over the alleged violation of the law. Thus, only the documents created or assembled by the investigating agency would fall under CLEIRs. For example, if one public office provides a copy of an otherwise public record to a law enforcement agency as part of the law enforcement agency's investigation, only the copy of the record, now kept by the law enforcement agency, would be covered by CLEIRs. The original record kept by the first public office, which has no investigative or enforcement authority over that alleged violation of the law, would not be covered by CLEIRs. That public office must still respond to public records requests for its original records, regardless of the status of any investigation being conducted by the other agency. If there's a joint investigation or another agency's laboratory or expert is used, the shared investigative records can belong to both agencies separately, and each agency is responsible for responding to public records requests for the records they are keeping. If both agencies have investigatory authority in the matter, then the records can be of a law enforcement matter for both agencies. So once we determine that the records pertain to a law enforcement matter by meeting each of the three parts to step 1 we just discussed, we are only then able to apply step 2 of the CLEIRs test, which means applying the specific information exemptions listed in the CLEIRs section of the Public Records Act. In the course of reviewing law enforcement matter records for exemptions, remember that the CLEIRs exemptions do not automatically cover an entire investigatory file, but apply only to particular records or parts of a record where the release would create a high probability of disclosing any of the following 5 types of information: the identity of an uncharged suspect, the identity of a confidential information source, information that would endanger the life or physical safety of law enforcement personnel, a crime victim, or a confidential information source, specific confidential investigatory techniques or procedures, or specific investigative work product. An uncharged suspect is a person that the agency actually suspected of the violation, but who was never charged or arrested for the offense to which the records pertain. Only the specific information that would create a high probability of disclosure of the suspect's identity may be withheld. This does not mean that the agency can deny that the investigative file exists, even if the request asks for the investigation of that specific suspect. The uncharged suspect exemption does not authorize withholding any records or parts of records which do not carry a high probability of disclosing the identity of the suspect. A confidential information source or confidential informant is any person that provided information to the agency in the course of its investigation and who was also promised confidentiality. Again, this exemption allows withholding only of the information which would create a high probability of disclosure of the identity of the information source or witness, and does not exempt the information they provided, unless, of course, particular parts of that information would create a high probability of disclosure of his or her identity. The agency may not assert a blanket policy to never reveal the identity of any information sources. Most courts have agreed that the information source must have provided their information in exchange for an agency promise of confidentiality. A law enforcement agency may not assert a blanket policy that releasing any information from a file might conceivably endanger the life or physical safety of someone, but must be able to justify why the release of the specific withheld information would create a high probability of disclosure of information that would endanger the life or physical safety of a particular law enforcement personnel, a particular crime victim, or a particular confidential information source in that investigation. The investigatory techniques and procedures exemption is intended to protect investigatory techniques or procedures which, if they became well known to potential offenders, would render those techniques or procedures less effective. It is not meant to withhold routine or well-known investigatory processes. Ohio courts have defined investigative work product as information assembled by law enforcement officials in connection with a probable or pending criminal proceeding. This includes notes, working papers, memoranda, or similar materials. Investigative work product can only be withheld under CLEIRs while the investigation is ongoing. The exemption cannot be used after the investigation concludes. That is, the exemption expires when all possible legal enforcement action and all possible legal challenges to a conviction have expired. For example, a criminal investigation might conclude when the charges are dismissed, the grand jury returns a no bill, the suspect is found not guilty in court, or the investigation is dismissed or abandoned in any other way. If the suspect is convicted as a result of a criminal law enforcement investigation, then the investigation concludes only when no further direct appeal, post-conviction appeal, or habeas corpus action is available to the convicted person. Remember, investigative work product does not include 911 recordings or routine offense and incident report forms that initiate an investigation. Generally, all of the CLEIRs exemptions apply throughout the prosecution of the case. This may be very quick, or the investigation and resulting prosecution and sentence may take decades or even a lifetime. As we already mentioned, whenever the investigation has concluded, the broadest exemption, the investigative work product exemption, expires. However, the protection for the other types of information, such as information about confidential informants or information that would endanger the safety of police officers or crime victims, lasts as long as the reason for the redaction remains true. In many instances, that may be forever. Like all public records exemptions, the CLEIRs exemptions must be read narrowly to cover only parts of a record to which they clearly apply. This means that in many cases only the actual name, address, or other specifically identifying information which would create a high probability of revealing the person's identity may be redacted. Other times, numerous pieces of highly identifying information or lengthy details of a confidential investigatory technique may take up so much of a paragraph, page, or document that the entire paragraph, page, or document is considered inextricably intertwined with the CLEIRs exempted material. If that is the case, then the affected paragraph, page, or document may be redacted or withheld in its entirety. Please note that this has never been applied by the Ohio Supreme Court to allow a public office to withhold an entire law enforcement investigative file. If you are a public office responding to a public records request, keep in mind that more than one exemption may apply to the same record. For instance, the details of a forensic analysis in a criminal investigation may be both a work product and confidential investigative technique or procedure. Or there may be an agency-specific statutory exemption for complaints filed with a civil or administrative law enforcement agency. Other exemptions, which often apply to records in an investigative file, include Social Security numbers, safety officer residential and familial information, leads and OLEG documents, and information referred for investigation by a children's services agency. If you are a law enforcement agency reviewing records to release, make sure you consider all exemptions, not just CLEIRs, which may apply to a law enforcement investigatory record. Criminal defendants and inmates have additional restrictions as to when, how, and from whom they may request records concerning their own investigative file or the investigative file of others. Remember, the CLEIRs exemptions only apply to records that clearly fall under the categories listed in the statute, and only for certain periods of time. Each investigative file will be different as to where and how the CLEIRs exemptions apply. Consult your legal counsel for assistance. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Ohio Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback.